Mr. Shah,
Yes.
one thing which is very clear is that there was no conditional surrender of sovereignty to the dominion of India. The surrender of sovereignty was absolutely complete.
Yes.
And once the sovereignty was unquestionably and fully vested with the dominion of India, then the only restraints which would apply would be on the power of Parliament to enact legislation, so on and so forth. A few restrictions which remain, which were also then, as we have seen, subsequently modified. And in fact, in the Constitution Application Order of 1972, which is CO 93, which we'll find at volume 3, page 52, the very interesting provision which comes in 1972. In 72, Article 248 was amended in relation to its application to the state of Jammu and Kashmir. And 248 was substituted, which provides for residuary powers of legislation in respect of all other states. 248 reads with entry 97. Now it says Parliament has exclusive power to make any law with respect to prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India. Therefore, the order of 1972 makes it now beyond the pale of doubt that sovereignty vested exclusively in India, and therefore no vestige of sovereignty was retained post the instrument of accession.
May I submit to Lords of this?
Is it correct that Article 248 now applies, 248 as it is applicable to the state of Jammu and Kashmir immediately before 5th of August 2019, contains an absolutely clear and unequivocal acceptance of the sovereignty of India?
I may respond to my Lord's observation. First is the instrument of accession.
3, page 52. What?
First, when there was instrument of accession, one legal question for my Lord's consideration is this: when you exceed, this was a general instrument of accession applicable to all the states. When you exceed, do you transfer your sovereignty to the union or not? That is answered by this court, fundamental. They said, no, you have not transferred your sovereignty in terms of only instrument of accession. You transfer it only by way of merger agreement. When I concluded,
what is superior? The Constitution of, sorry, what is superior? The Constitution of India?
Of course, it's Constitution of India, but there's no doubt about that.
Constitution of India is the merger agreement. The
not merger agreement, instrument of accession. But with 370 in it. If it was no 370, it was different. My lords are,
ultimately,
understand your lordship's mind that one is Constitution of India is there. Your instrument of accession goes, your sovereignty goes, your everything goes.
Ultimately,
but it doesn't seem to be like that, because this is something which has been there for 69 years. This is how the governments have worked it out.